Well, welcome. Good morning to Sunday Coffee with Dr. Childress here today. Today, I'm hosting my Sunday conference in my living room because um, I don't have permission to leave my couch. Let's put it that way. This is typically how we start our mornings, and Mr. Pippin is particularly relaxed this morning. What I want to talk about today is uh, a catalog of concerns. Now, this is what I generate whenever I do a forensic custody evaluation. I do a line by line on those because the concerns are so dense in the forensic custody evaluations that I can't do it section by section or ideas or anything like that. I have to go through line by line on these custody evaluations. So it's pretty time consuming. But what that does though is it as I go through it line by line, I generate a catalog of concerns, a consistent concerns that arise across custody evaluations and within that particular evaluation. And so rather, I found when I was doing line by lines, I was always cut and pasting from the previous comments because they always say the same thing. So the concerns are always the same and they're over and over again. And so what I found as an efficient way to um, analyze the evaluations or document my concerns um, is I will state the concern the first time and then just cite the title of it the every other time it appears as a concern. And so that makes it a lot easier. I don't have to fill in with a lot of text. And then I have a companion piece called a catalog of concerns that also gets generated. So I have two documents that come off. One is, well, let's see, one is the line by line review, and the second one is the catalog that's generated off of that. And so today, I just finished a line by line review. I'll be doing the report later this week, and that's what my report is generated from is the my notes from Appendix 1, my line by line, and the concerns that were raised. And then those both get supported. Those are supporting documents to my summary and analysis report because it's going into the court. Court likes documentation, they like evidence, and we need to stop the fighting around these children. And so and improve the standard quality of professional services. So rather than getting locked into the staff splitting where everybody's fighting around the patient, we need to elevate the standards. And so that's what I'm coming in. I'm not fighting about it. I'm just going to tell you what the problems are. Um, and I anticipate that this catalog of concerns that I'll be publishing it to Amazon. Oh, you say he doesn't like the idea of me talking with you here. Anytime I get distracted, he says, "Nah, I don't like this." Um, and so I'm anticipating publishing it. I was hoping October, but more likely December-ish. And because if I'm doing an analysis of these forensic custody evaluations, I feel really bad, like putting them in such difficulty because they deserve it. I mean, they're practicing beyond the boundaries of their competence, they're unethical, a lot of problems. But I feel uncomfortable doing that without telling them ahead of time what they can do to address the concerns or what the concerns are so that they can address them. And so that's where I'll be putting out a catalog of concerns coming forward. And it might be of help to parents as they advocate, various advocates for the problems, can cite to the catalog and things, as well as perhaps address some of their own mental health professionals relative to the problematic practices. So anyway, I'm going to be discussing giving you an example of a table of contents from a recent catalog of concerns that I just finished yesterday. And just to give you an example of what that is going to be, and then I will produce the catalog, a general catalog, it come hopefully December, Christmas present for everybody. So let me start. This is what the table of contents look like, basically. And it's really, really small because there's 28 concerns. By the time I finished with the custody evaluation, and we'll go through the topic areas for each one of these, but there were 28 concerns of substance relative to this, some large, some small. And so that's what the table of contents would look like. Then to go through each of them, the oops, uh, let's see. Yeah, there we go. Um, so the first one is separated family structure. So this began likely right at the start of the evaluation, because what I do is, as I'm going through line by line on my first reading, whatever concern shows up, that becomes the first one. The next one becomes number two. The next one becomes number three as I encounter the concern. And so while the concerns remain relatively the same across evaluations, the ordering of them and sometimes the specific ones change with the evaluation. This is a pretty standard one to show up, and it's a pretty standard one to show up right at the beginning. And it's where, with this particular one, the custody evaluation evaluator is framing what the referral question is to them. And basically, my question was that came up at that point is that the question for the court's consideration in this family regarding the decision making surrounding is the is its decision making surrounding which parent is more likely to lead this family into a healthy and normal range post divorce separated family structure that will allow the children's healthy and affectionate bonding with both parents. And so that's a really small one. Some of them get pages and pages, but that one's just a simple paragraph with a diagram. And you can see in that diagram that there's two possible divorce transitions. Either you go to a normal separated family after the divorce where both the child's bonded to both parents, or it transitions into a pathological cutoff family structure. And so that's basically the family is just transitioning from an intact family structure that was united by the marriage to now a divorced family structure that's now united by the children. But if the conflict between the parents gets too much, it's just going to rip the family apart, and then the child is going to be on one side or the other. And so we want to keep the conflict between the parents relatively low so that the child can serve their function of bonding to both parents and holding the family together, basically. So that's the issue. And so if one parent is moving this and their leadership is going to drive this into a pathological separated family structure, and the other parent is more likely to lead this into a healthy, well, then that's a consideration for the court. Which parent is more likely to give us a healthy family structure from their leadership versus the other parent who's going to lead the family into a destructive path? So that's concern number one. N- Now, then I go further into um, the evaluation. And so you can see here on the first six concerns, these are from the table of contents. The first one is that separated family structure. Number two was competence concerns. So the next issue I had is the forensic custody evaluator competent in the assessment of delusional thought disorders, in attachment pathology, in family systems, in complex trauma, in personality pathology, um, and the domains that they need to be competent in becomes my next question. And with this particular evaluation, the next question that arose was about family systems pathology. Now, with the competence ones, I have like yes, no kind of questions. I just list them all off and say yes, no, that all needs to be answered. For the family systems, that's about 3 pages of just describing basic family systems. What is a triangulation? What is a cross-generational coalition, emotional cutoff, just describing enmeshment, just describing the constructs of family systems. And so that became relevant because there's triangulation of the child or a cross-generate. We're concerned about cross-generational coalition. So I describe what the family systems constructs are. And then every time a cross-generational coalition, the symptom is evidenced in the reporting, or child triangulation, or an emotional cutoff, every time those symptoms are reported by the forensic evaluator, well, then that's concern number, what is it? Three, uh, family systems pathology. Here's a symptom of cross-generational coalition, family systems. Here's another symptom of cross-generational coalition. Number 4, on this particular one was persecutory delusion. So obviously something came up about the child feeling afraid, and so is that a persecutory delusion? The next one is parenting strategies assessment. Now, this becomes a relevant concern when the talking about the targeted parents parenting. So apparently, likely, the custody evaluated started with the allied parents reporting, and the allied parent was saying how the child is afraid of the targeted parent. So, is there a persecutory delusion? And then I frame that out and describe what all that is. And so, every time after that, I could just refer to the title. Um, and then the next issue that likely got brought up was the parenting practices of the targeted parent. Complaints about the parenting practice. Well, com- if you're worried about parenting of somebody, do a parenting assessment. That's applied behavioral analysis. You identify, are they using response cost or timeout or physical discipline? What do they do? And that's really easy to do. You just do an applied behavioral analysis. You pick up one or two, maybe three, but typically around two of the worst parenting interactions that everybody's describing, and you walk it through step by step. What did they do? What did you do? What did they do? What did you do? And you walk it through with both people, sometimes together, sometimes separately, and you find out what triggered the conflict, step by step, and what was the parent's response to that conflict. Did they take stuff away? Response cost. Did they send the child on a timeout? Did they get involved physically with physical discipline somehow with the child? Morality. Are they trying to teach morality, lecturing? What are they doing? And so you document that. So that would be a parenting strategies assessment. So I explain that in the concern. And then every time that comes up, I can just say, get a parenting strategy assessment. Next one, virtuous victim signaling. So yeah, it's probably pretty clear that this is a targeted parent the allied parent who's reporting first, and they're presenting as a virtuous victim. And that is associated with the dark personalities. And so that's becomes a concern. And also, every time that symptom gets reported into the reporting of the forensic psychologist, I can just pop out number 6, virtuous victim signaling. Then the next one became the differential diagnosis, DSM-5, ICD-11. Now, for this one, again, I go through yes, nos, and I say, basically, this is our differential diagnosis. We got child abuse possibilities from the targeted parent. We got psychological child abuse, persecutory delusion, factitious disorder imposed on another from the allied parent. Those are your diagnoses. So you can see how I'm just sort of framing up what the issues are that they're reporting to me and what that's triggering in terms of what should be addressed and what should be considered and as part of the analysis by the forensic custody evaluator. The next one that came up was dangerous pathology and risk assessment. Yep, that's pretty common after um, the differential diagnosis because two of the differential diagnoses are spousal abuse and child abuse by the allied parent against the targeted parent and allied parent against the child, psychological abuse of the child, delusional disorder, factitious, and spousal abuse of the targeted parent by the allied parent using the child as a weapon. So, since you got at least two dangerous pathologies. Then you have the allied parent and the child making child abuse allegations against the um, targeted parent by the child's symptoms. The child's trying to flee a parent, so they're making the symptoms themselves are making the allegation, as well as potentially verbal allegations that the child is somehow being malevolently treated in some way. So I've got child abuse concerns on both sides, and at least uh, spousal abuse on one side from the targeted parent about the allied parent, and potentially I get, the allegations of, spousal abuse during the marriage and various things from the allied parent. So I've got dangerous pathology. So the forensic custody evaluator now has duty to protect obligations. So now they have to do a proper risk assessment or ensure that one gets conducted for the differential diagnosis of child abuse. Uh, and that's why it's important to shift from parental alienation, when you'll talk about that later, to child abuse, because that activates the duty to protect obligations to get an accurate diagnosis of what's going on. So then comes up psychological control that becomes relevant to um, shifting from that. This is bad parenting. Okay, so what we're really focused on clinically is the child's symptoms and resolving the child's symptoms so that the child has a normal range childhood. But we got parents that are doing bad things or problematic things, influencing the child, negative influence on the child. And that particular component, the cross generational coalition, involves psychological control. So every time that becomes a symptom, we quote all the literature on psychological control in the concern, and then I can just reference number 9, psychological control, whenever that shows up. Professional standards of practice. Okay, so now that number 10, professional standards of practice, is what I will pop in every time the evaluator uses the terms, these euphemisms, parental alienation, resist refuse dynamic, or parent child contact problems. All three of those are euphemisms for child abuse and they're of made up pathology labels. None of those exist outside of like their imaginings of the forensic psychologists in the courts. There's no parental alienation in the DSM-5. There's no resist refuse dynamic in the DSM-5. There is no parent child contact in the DSM-5 or in any diagnostic system. So they're just making things up. And it's a euphemism to hide the child abuse. They say it's resist refuse dynamic. No, it's not. It's child psychological abuse. But you're hiding it behind your euphemism. And that's why we need to stop parental alienation. Stop using that term, parents, because here's the situation. Okay, here's the situation. Let me talk to you about this for a second. Because this parent in this situation used the term parental alienation. So the forensic evaluator started saying, is this parental alienation? And decided, no, it's not, because it didn't match the features of true alienation. Yes, it did. It was a persecutory delusion in a parent who's imposing it on the child. Okay. It's a factitious attachment pathology imposed on the child. It met diagnostic criteria for the DSM 5. But when you allow people to just make stuff up, like they say, no, it's not parental alienation. And you go, geez Louise. So stop using it. You're giving them permission to be ignorant. Okay, when you do that. So stop using that term. Use cross-generational coalition. Now they have to know family systems. Use persecutory delusion. Now they have to know family systems. And if you're bringing me a report for second opinion, that you've done that, and they say, well, the parent says, is worried about a delusional disorder with a persecutory delusion. Now I'm reading that saying you as a psychologist have to do a proper assessment for that, which is a mental status exam with all perception, or you need to get consult on that if you don't know how to do it. And then I link it into competence and the ethical violations, and I can really work them up bad. But when you use parental alienation, I have to compensate for you. So that's where, when you use parental alienation, I have to add number 10, professional standards of practice, or if they use their new made up stuff of professional standards of practice. And every time they do that, I pop that in. So then after this, it's a factitious disorder imposed on another. That's a false attachment pathology imposed on the child. So you can see how I'm lining these things up. And then the invalidating environment that came up for some reason. Um, uh, the oops, choo, choo, choo. Yeah. So yeah, I got lost in my slides. Okay, dangerous pathology, psychological, factitious disorder, invalidating environment. That's a brief one. That's Marsha Linehan. When the child, that's what everybody says, gaslighting. When you say gaslighting kind of thing, that's an invalidating environment. When they do it to the child's not, they're invalidating the child's authenticity and the reality of things. And so I just add that one. I think I'm going to be saying that a lot. Then comes the attachment pathology. That's another large one where I describe the attachment system. It's a motivational system. That means it always has direction. It doesn't go up or down. It always motivates towards bonding to the parent because the other motivational direction is death by a predator. So it's motivating the child to bond to the parent. When you have a change in the motivational direction of a motivational system, that's child abuse that causes that. A child seeking to flee a parent to the predator because that parent is so bad. Okay, that's child abuse that causes a child to want to flee. So the question becomes which parent? Either it's authentic child abuse, in which case that's an authentic attachment pathology caused by child abuse, or it's a false or factitious attachment pathology being caused by the allied parent who's creating a persecutory delusion in the child to damage and destroy the child's attachment bonding. So it's either a true attachment pathology where the child's trying to flee a parent, or it's a false attachment pathology, factitious disorder imposed for secondary gain to the allied parent. So there's your differential diagnosis. So factitious disorder, validating environment, I explain attachment pathology, educating the doctor, competence concerns. Now, this is a unique little one. So if I have the you, the parents, giving the material to educate the forensic psychologist, likely my material, and they are acknowledging the patient gave me material to, that's going to prompt educating the doctor because patients should never have to educate the doctor. The doctor should already know. So now all of a sudden, I've got competence concerns if I have a patient educating the doctor. So then we go back to what is it, number two in this situation? Um, number two is competence concerns. So then when I reach number 14, educating the doctor, then I'm also going to put 14 followed by 10, which is competence concerns, followed by differential diagnosis, probably, and risk assessment. So I'll have four of those in a sequence relative to you giving them information to about the pathology. Something came about dark personalities. Now, dark personalities typically get triggered on the manipulation as a symptom because when manipulation pops up potentially as a symptom, that's potentially Machiavellian manipulation characteristic of dark personalities. And that's what we're kind of concerned on narcissistic borderline darks. So if there's a symptom or something that pops up about possible manipulation, then that dark personalities gets entered into the picture. Does that mean there's a dark? No, it doesn't. It just means we have, in that particular situation, one indication of that. Similar to if I have a child whose symptom is being very active, well, that's a ADHD symptom. So I'm going to toss in possible ADHD as a relevant diagnosis for the child. Does the child being very active mean they have ADHD? No, that's just one symptom. But if they're also, get distractible and intrude into people, so if they have a number of these symptoms of hyperactivity and inattention, then yes, that's part of that symptom. But if it's autism spectrum, they may be very active and that activity symptom fits better into a diagnosis of autism, well, then that's where it is. But now we have manipulation. So is it, dark? Maybe. So let's consider that. And then we start to see if there's other indications of a dark personality in the situation. Negligence. Okay, so this is another brief one, but if duty to protect obligations are active and competence, man, they should be doing an assessment of like the right stuff and child abuse, and they're not, then they're failing in their duty to protect and potentially negligently. Then came discussion of behavioral psychology. Stimulus response led into a discussion of functional behavioral analysis. Now, this is the first report I actually did a functional behavioral analysis concern, because the child's symptoms that were being reported would really benefit from a functional behavioral analysis. And so I educated about that. The functional behavioral analysis is in behavioral psychology, and it uses applied behavioral analysis to start with. And that's really good because you can develop parenting strategies from an applied behavioral analysis. You can understand which parent is cueing the child's behavior and all sorts of things. It solves the clinical issues if you know how to do behavioral psychology, which they don't. Things like stimulus control. Is the child's behavior under the stimulus control of the targeted parent? If not, then you can change the targeted parent till the cows come home and the child's not changing because the control is coming from the allied parent. So you can tell that if you do an applied behavioral analysis, but they don't. So that was, what was it, number um, 17 was the applied behavioral analysis and stimulus control. And then I led into number 18, which is a functional behavioral analysis, which is off of that. Now, mind you, a functional behavioral analysis is so standard that it is required of all school systems in the United States whenever they want to put a behavior plan into the classroom. So if you have a kid who's acting out in the classroom and the school psychologist wants to put in some sort of reward or reinforcement program for the child, they first are required by the Individuals with Disabilities Act um, idea to do a functional behavioral analysis. So all school psychologists, master's level school psychologists, know how to do a functional behavioral analysis. No forensic psychologists in the family courts know how to do it. So the family courts are receiving lower quality mental health services in our school system, which is really problematic given the nature of the decisions the family courts have to make. Now they're going to affect the lives, and they're getting really low professional standards. So, negligence, the two behavioral things, treatment indicated. That was likely off of the functional behavioral analysis. Whatever the kid was doing was extremely concerning. So we need to get treatment in on this for whatever the symptoms are being presented. That's not typically one I include in forensic custody evaluations. Always we need treatment. Always, always, always. And let me emphasize that to parents. In fact, let me seriously emphasize that to parents. We always land on treatment, not diagnosis, not assessment. The assessment is to get us a diagnosis, and the diagnosis is so we can treat. We always land on treatment, fixing it. And we need a diagnosis because is it cancer we're fixing or diabetes we're fixing? Because the treatment is going to depend on our diagnosis. So we're going to need a diagnosis, and we're going to need an assessment to get that diagnosis. But your goal is not to get court orders for the assessment. Your goal is not to get the diagnosis. Your goal is to get this fixed so your child has a normal range, healthy childhood. So we always land on treatment. And that's where the forensic psychologists got off track. They came up with this new approach that they just made up where they have a quasi judicial role. And they say that. They say, "We're not treatment providers. We don't help people. We don't alleviate distress. We are in a quasi-judicial role of helping the court decide on custody." The court doesn't need help on that. The court needs to know who's abusing the child and who's causing the child's pathology. Once it knows that, the court can make decisions on custody. Okay, doctors need to diagnose pathology. If we don't diagnose the pathology, that leaves the court to diagnose it, and the court is not trained. The judge went to law school, not psychology school. That's why he's asking the psychologist for a diagnosis. So the psychologists need to step up. Come on, doctors. You're a doctor. Diagnose the pathology using DSM, ICD 11. Don't not made up stuff, real professional practice. Diagnose it using the diagnostic systems. Once you do that, the judge can then make his decisions or her decisions based on your diagnosis. But if you don't make a diagnosis, you're failing in your duty to protect obligations because it's possible child abuse and you're not giving proper direction to the court. So, yeah, so negligence is problematic with these folks. And didn't do that. So then treatment was indicated, and then something came up about splitting. So I put a little piece on splitting. That's another small one that could potentially be used. Every time there's a symptom of splitting comes up, I put in number 20, splitting. Ethical violations. Okay, so at this point, in the review of documents, I'm probably, 2/3 of the way through at this point. And so I've hit ethical obligations. I'm concerned because probably standard 2.04, the application of knowledge. At this point, I'm not seeing any application of knowledge. So they probably started into some sort of analysis that I'm waiting. Are they applying knowledge to their as a basis for their professional judgments? No, they're not. If they are not applying the established knowledge as a basis for professional judgments, then they are in violation of 2.04. If they are in violation of 2.04, they are in violation of 9.01, that their opinions are not based on information and techniques sufficient to substantiate their findings. So that's the um, 21 is when we start to get concerns about their ethical violations. Euphemisms for child abuse, well, there it is. They're starting to analyze the family conflict using constructs like resist refuse dynamic or parental alienation or something. So the first thing that comes up if they're using these euphemisms, I've already said, so I'm going to say number 10, professional standards of practice, number 21, ethical violations, and then I added another one, number 22, euphemisms for child abuse. Now, I talk about the euphemisms as an issue in the professional standards of practice, but here I broke that out as a separate concern because they're just using resist, refuse, or parental alienation as a substantial basis for their judgments, and those are not DSM or ICD diagnosis. Again, let me emphasize this to you, all you parents, about these parental alienation experts out there, experts, quote unquote, that are saying, "Oh, there's parental alienation, and we need to get this into the DSM-5." Or, no, you don't. It's all the pathology's already in the DSM-5 if you just apply it. And that's why it's so problematic for these Gardner PAS experts to be spreading medical, psychiatric, psychological misinformation on the internet about that. We're discovering a new pathology unique to the family courts called parental alienation with these unique new symptoms and everything that degrade the quality of mental health services and that prevent effective intervention for the child abuse because they're not diagnosing it, they're not calling it child abuse, nobody's aware of it, the court's not aware of it. Courts thinks it's parental alienation, this new form of pathology that's so controversial. No, it's not. It's a factitious disorder. It's a shared delusional disorder. It's child psychological abuse, all of which are in the DSM-5. When you apply the DSM-5, ICD-11, then you'll get a diagnosis of child abuse and we can protect the child. So do that. So stop using these made up pathology labels and actually go and get a real diagnosis for the situation. So euphemisms for child abuse. Oh, here we got the observation period I reached, and there's something about the observation that was troubling, so we got biased observation. And then we have breach and repair. That's Tronic and Gold. So basically, in breach and repair, that's just like 6 quotes from Tronic and Gold about we always repair the good, the bad, and the ugly. The good in attachment relationships, the good is breach and repairs. They're going on all the time, and that's the good stuff. The breach and repair. The bad is when there's a breach that's not being repaired. That's bad. Then you see a lot of protest and ooh, ooh, ooh. The ugly is leaving the breached attachment bond unrepaired. That's the worst possible thing we could do. That's the ugly of Tronic and Gold. Okay, is to leave. We always want to repair. Always. Okay, that's healthy. And it's not only healthy, it's essential for healthy development, this breach and repair sequence in normal range. So if I get a mental health person ever recommending that we leave the child's attachment bond unrepaired, no, they are absolutely ignorant, incompetent, and destructive. We always repair. So that's why we land on treatment. What's the treatment plan to repair? I don't care what the problem is. I don't care what the problem. I don't care what the problem is. We always repair. So how do we put it on a treatment plan to fix the problem? You got child abuse. Well, let's fix the child abuse. Okay, let's protect the child. Let's do what we need to do, but let's repair. Okay, that's what we do. Now, got an alcoholic parent and everything, you can't, because that parent's obviously deficit. But if that parent's cooperative and willing to work with us, we're going to fix that parent-child bond because that's in the best interest of the child. It's always in the best interest of the child to fix things. So, breach and repair. Now you can see I'm getting into possible misdiagnosis. Yikes. This is the one possible misdiagnosis. And it's titled a little bit differently in some cases. Sometimes I entitle it participation in child abuse because if you misdiagnose a shared delusion, you become part of the shared delusion. You become part of the pathology. And when that pathology is child abuse and you've misdiagnosed it and you believe a shared delusion, you become part of the child abuse. And when it's spousal abuse using the child as a weapon, you become part of the spousal abuse. So these forensic psychologists and reunification therapists and individual child therapists become part of the child abuse and part of the spousal abuse because they are misdiagnosing the pathology. Why are they misdiagnosing the pathology? Concern number two, competence. They are not competent in delusional thought disorders. And so they wind up misdiagnosing a delusional thought disorder, believing it's true. And then they wind up being participants in the child abuse because they're practicing beyond the boundaries of their competence. Okay, so that's the fundamental issue is we need to elevate the standards of practice in the family courts to the APA ethics standards for competence 2.01. You must be competent with autism if you're diagnosing and treating autism. You must be competent with eating disorders if you are diagnosing and treating eating disorders. You must be competent in heart surgery if you are doing heart surgery. As a doctor, you are required to be competent with the pathology that you're assessing, diagnosing, and treating. If not, get consultation. If not, get training. You're not allowed to just go in and willy-nilly make up new pathologies to hide your ignorance and destroy families because you're incompetent. That's negligence. We got duty to protect obligations. So, possible misdiagnosis. That's that one. And you'll see it when I get this published up. Possible countertransference bias. Okay. And so you can see where I'm heading with these concerns. And then violation 9.01. Yep, there it is. That their opinions as expressed in their reports, recommendations, diagnostic and evaluative statements, including their forensic testimony, which I'm not reviewing, is not based on information and techniques sufficient to substantiate their findings. Standard 9.01 cites directly to standard 2.04. So that'd be DSM 5 and ICD 11. Standard 2.04, bases for scientific and professional judgments, DSM 5, ICD 11. Start with that. Attachment pathology, delusional thought disorders, family systems. Okay. Boom, boom, boom. Factitious disorders. Boom. Complex trauma. Boom. Personality disorders. All of those. Okay. There is no acceptable ignorance when you're involved with a patient. Okay. You need to know everything you need to know about the pathology. Don't be lazy. Okay. If you're going to be lazy, go somewhere else. Don't work in the family courts. But a doctor always starts with the diagnostic systems. I don't agree with the DSM. I don't care. Your doctor. Give us our diagnosis, and you can challenge it and say, "I don't believe the diagnosis. I don't believe the APA knows what they're doing." You can, but you're a doctor. Okay. ICD-10, ICD-11 has the diagnostic codes for all medical and psychiatric disorders. If you're a medical doctor, you come back with your medical diagnosis, you put in the ICD-11 code and you send it off to billing, and that justifies your treatment for the cancer or the diabetes or the high blood pressure, whatever you're treating medically. Psychiatric, delusional thought disorders, factitious disorder imposed on another, DSM-5, diagnose what the pathology is. If it's not there, say it's not there. Or if it's a rule out, put it as a rule out. But you have to use a DSM. Okay, so there's your violation 9.01, bases for assessment. Then we got differential diagnosis in healthcare. That's the one I end up on. Likely for this one, it describes working diagnosis and how you make the diagnosis. You start with a working diagnosis, and that's typically a differential diagnosis where you got several possibilities that could explain the symptoms. And then you take that differential diagnosis, you systematically collect the necessary information to make your differential pattern. Which pattern is it fitting into? Does that symptom fit into, cancer, or does it fit into diabetes? And it can go either way. Angry can be a symptom of a lot of things. Anxious can be a symptom of a lot of things. So which diagnostic pattern is that symptom fitting into? So you start your working diagnosis. You do diagnostic modification as you start to collect information. You're matching up to some. You're not matching up to other patterns. And then diagnostic verification is the final step. And diagnostic verification is why we shouldn't be making, or we're not allowed to make, diagnoses of people if we haven't talked to them, because the talking to them is where I'm going to do the verification. I can come up with all my differentials based on the symptom reporting. I can come up with modifications based on the symptom reporting. But the final step is to verify the diet. And that's where I will have like several elements of the pattern, but I'll be missing a couple, okay, of the pattern. But then if verification is for me to go in and ask, is this symptom present? And yes, it is. And then I ask, is this symptom present? And yes, it is. And so now I've identified two that weren't there, that weren't being reported, but should be part of the pattern. Sure enough, they're part of the pattern. So now I've got a verification of my diagnosis. I can also do it by response to intervention as well. So there's 3 steps. You develop your working diagnosis, differential diagnosis, and you modify it based on information, then you verify it. And so that's the final um, one, the differential diagnosis in healthcare. So with that, I'm going to wrap up my Sunday and head on out. So this is a catalog of concerns for forensic custody evaluations. You can expect it hopefully coming out around Christmas time, a Christmas present to everybody, which would be general catalogs of concern. It might not include all of the ones specific to individual things. For like example, splitting. Well, I might include splitting on it because, Euphemisms for child abuse, that's typically under professional standards of practice. But again, I might just bring it out just to emphasize the point that stop using euphemisms that hide the pathology from the court's understanding and from effective intervention. If it's child abuse, say child abuse. It's not inappropriate affection, it's child sexual abuse. It's not overly harsh discipline, it's child physical abuse. And it's not parental alienation, and it's not resist refuse dynamic, and it's not parent child contact problem, all made up stuff. It's child psychological abuse in the DSM-5 V995.51. Okay, so when it's child abuse, we have to use the term child abuse. Now, if you don't think it is, then explain why not. If you don't think it's spousal abuse using the kid as a weapon, explain why not. Okay, but you at least have to consider it and explain it. The Let me say something about reports out of the mental health people. In the healthcare system, the doctor is commensurate to the judge in the legal system. We're at the top of the healthcare system, just like the judge is at the top of their system, okay, the legal system. So, judges and doctors. So, when a judge returns a verdict on a case, they explain the evidence, summarize it, the evidence that was presented, the applicable laws to that evidence, and their decision related to the applicable laws and the evidence, so that when it goes to an appellate court, the appellate court understands the judge's reasoning, understands what the evidence was, understands the laws applied, and understands the decision of the judge. All of that should be very clear to the appellate court. The same is true for the doctors in the healthcare system. So when anytime a doctor writes a report and it comes in for second opinion, hello, the symptoms should be clearly explained. The relevant diagnostic criteria for those symptoms that was applied should be described. These are the diagnostic criteria that were applied. And this is a decision, the diagnosis, based on the application of the diagnostic criteria to the symptom evidence. Just like the judge does, the doctor should do the same thing. Okay, and it should be clearly explained, just like the judge's decision should not be. I should not have to guess whether the judge decided the person was innocent or guilty. When the judge's decision comes back after a trial, we don't have to guess. Did the judge find him innocent or guilty? I don't know. We should not have to guess what the doctor's diagnosis is. That's their obligation, to explain their diagnosis clearly, which is the DSM-5 ICD-11. That's why they exist, for professional communication, to explain clearly from one doctor to another doctor, from the judge to the appellate court, exactly what criteria, exactly what laws were applied to the evidence to reach your decision. That's why they exist. Apply the DSM-5, ICD-11, you will have a solution to the family courts immediately, because you're going to elevate the competence level in the doctors immediately, because now they're going to have to justify what they're doing. They're going to have to show what they're doing. If you don't do that, if you just leave the situation, then guess what? I become a second opinion review to them one by one. And I'm fine doing that. Okay. I'll go through them line by line. I'll generate a catalog of concerns. The other thing I do is generate a checklist of applied knowledge to see, document whether 2.04 was met. And then that leads to 9.01. So then they can file a licensing board complaint on violation to ethical standards and failure to duty to protect. And I'm fine doing that. Okay. So that's, until we get change, I have job security, reviewing mental health reports generally, reunification therapists, done a couple of those, and do a line by line typically on them as well. And individual therapists. I just started doing individual therapists recently, looking at their notes. For the individual therapist, it's the notes, and you look right at the intake report, intake thing. Did they apply the knowledge to all the concerns? So I'll be reviewing the mental health people as a second opinion, and I'm gonna be giving them exactly what I'm looking for, hope as a Christmas present, Catalog of Concerns. So as soon as they change and start applying the established knowledge, start applying the DSM-5 and ICD-11 to their diagnostic judgments, or professional judgments, then you're gonna fix everything, in the family courts. The and now what that means is that we have a tremendous conflict of interest among the forensic psychologists, because the moment they start applying the knowledge, they admit they haven't been doing this entire time. The moment they stop doing their quasi judicial role of a custody evaluator and start doing their doctor obligations of diagnosing and treating pathology, then they admit that they failed in this role of quasi-judicial role. It was a complete and absolute failure, and it is. Okay, they experimented on parents and it failed. But the moment they change, the moment they change, they don't know how to do clinical diagnostic assessments, and they're going to have to learn and educating the doctor that they're not competent to begin with if they have to be educated. And so they all just need to go away because they're not competent. But they don't want to go away because that's how they make their house payment, their car payment. That's their status. They got status in their professional career, all from being a custody evaluation in their experimental role. So they don't want to create the change that is necessary to solve the problem, a diagnosis using the ICD-11 and DSM-5 system. They do not want that. And so they are going to disable the mental health response to the family pathology for their own financial and career status gains. That's the current situation we're in. We need to change. They don't want to change because that means they go away and admit that they were a failure. So that's where we stand. And so I'll be doing it line by line, and they can submit their forensic custody, or a parent can submit one of their custody evaluations to me, and we'll see what their intransigence leads to. And with that, though, I'm headed back to Mr. Pippin and taking care of him. He's probably upset that I'm talking to you. So with that, I'll head back to my my Sunday here. Good luck, everybody, and we'll talk to you next week.